Thank you so much for joining us today for our virtual statewide education program entitled Vital Legal Issues for Dementia Care. Very exciting topic. The Alzheimer's Association provides monthly virtual and in-person education programs on dementia-related topics to aid and assist caregivers as they navigate the waters of caregiving for and loving someone with dementia. So, as a reminder, this session is being recorded. Please remain on mute for the presentation. And remember, it is important to turn off your cameras if you do not wish to be seen. At the end of the program, we will have time for questions. You may use the chat if you have any questions during the presentation. We will be monitoring the chat to answer any questions at the moment, and some we will save for our wonderful presenters to answer at the end. So today we have two wonderful presenters. First, we are starting with Lori Adamschick, an elder law attorney and the co-founder of the specialized life care planning law firm of Rulon and Adamschick, located in Honolulu. Lori discovered her passion for elder law as the result of her experience as the primary caregiver and advocate for her late parents. Lori is a veteran administration accredited attorney and member of the National Academy of Elder Law Attorneys. Oh, wow, Lori. And the Hawaii's Estate Planning Council. She is president of the Hawaii Pacific Gerontological Society, and she serves on the board of directors of Kuko Maya. Lori, that is absolutely amazing. Um, so now we will move over to Roland. So Mr. Roland Lee um, has been serving as the public guardian director for the Office of the Public Guardian since 2019. He has a diverse career path in social services that began in 1995 as crisis workers for Hawaii Suicide and Crisis Center, which gave him the opportunity to work with people living with mental illness and substance use disorders. In 2002, Roland moved to help his parents in the child welfare system, to help parents in the child welfare system better themselves. He graduated from the University of Hawaii in 2016 with two master's degrees, one in social work with a concentration in gerontological and another in public administration with a concentration in public policy analysis and organizational change. Wow, guys, those both were a mouthful. Moving to probation in 2018, he procured services for prohibitioners and implemented special projects such as alcohol monitoring devices for the courts. With 30 years of work experience, Roland has acquired a deep understanding of various systems, life, and issues, and he cares about people under guardianship. He keeps an active lifestyle and likes to cook, exercise, and spend time with his family. Those were two outstanding bio guys. So without further ado, we will hand it over to Lori, who will start this presentation. Over to you, Lori.
Thank you. Let me see what's going on with my slides. There we go. Yes, so good morning, and thank you all for taking the time to attend this morning. As Gina mentioned, we'd like to talk to you about what I call the vital legal issues that you may be facing when you're caring for a loved one, particularly with dementia. When there is a serious health event or diagnosis, it often lands a person in the hospital. And that what follows is then what I call the avalanche of issues, connected issues that often neither the patient nor the family anticipated. So let's just take a case study here. The case of Mrs. Tanaka. She had a serious urinary tract infection that put her in the hospital. And what when she went in, she had some pre-existing memory issues, but now they have become significantly worse, which is not unusual following a hospitalization. She can no longer remember how to dress herself or take her medication, and her family has now been told she's going to be discharged in a few days. And they are suddenly faced with this avalanche. On top of all of the issues that they don't know how to solve, there's the emotional issues that become part of this. The avalanche of issues usually covers three areas. First, personal care needs. What are her long term care needs? We just heard that she can no longer take her medications or dress herself, but what about showering? What about feeding herself? Who's going to provide the care that she needs? And what are her options for care? Where can care be provided? Can she go home? And if not, what are her options? Maybe move in with her daughter or move to assisted living or a care home. But how does the family choose and how do they determine who will offer the best care? The next set of issues really surrounds her finances. What is care going to cost? Where are her financial accounts and how is she going to pay for it? Perhaps a family member can provide care to save a little money. But if not, can she afford home care? Can she afford perhaps assisted living? How much does that cost and how much money does she have? And then finally, the set of issues that really stymies a lot of people are the legal ones. Does she have a power of attorney? Did she give somebody authority to help with finances if she's unable to? Does she have an advanced health care directive? Did she give someone the authority to help make medical treatment decisions if she's unable to? And if she did not create these documents and give someone authority, does she still have the capacity to create them now? So consider the family member that you're caring for. Do they have these documents? And what happens if there are no legal documents? Well, first, let's talk about the power of attorney. The power of attorney, as you may know, is a document that names someone to act as agent to help manage a principal's or the, the loved one's financial affairs if they're not able to do so themselves. By law, the power of attorney document these days now, they are still effective even if a person becomes incapacitated, unless the document expressly says otherwise. But you need to look at when the document becomes effective, when the authority becomes effective. Some are effective as soon as they're signed, some not until the person has been declared incapacitated. And that may mean an extra step has to be involved in getting perhaps the written opinion of a doctor, or maybe the written opinion of two doctors, depending upon what the document itself specifies. So each document, each power of attorney document, it's not a cookie cutter document. It needs to be carefully reviewed to determine when it becomes effective. If there is no power of attorney, does your loved one have the capacity to sign one now? Well, what does that mean? What does capacity mean? For us as attorneys, we evaluate legal capacity in simple terms as the ability to understand and make rational decisions. And for someone who's got dementia, this is something that often waxes and wanes, meaning you might have it this morning, you might not have it this afternoon. You might have it today, but not tomorrow. It is not a black and white issue until a person gets into the later stages of dementia. And the determination of legal capacity uh, may differ depending upon the document or the task at hand. So the questions that we would need to ask would be different for a power of attorney than for, say, a will or a trust. There is a legal presumption that a person has capacity, but in this case, thinking about Mrs. Tanaka, would she have the capacity to sign a power of attorney now? What if she never had that urinary tract infection and was never hospitalized? Did she have it then? This all raises the question of her ability to understand and make rational decisions. And this needs to be evaluated anytime a legal document is to be signed. As you can see, capacity is often a moving target, and it depends upon the person's condition. So if there's no capacity to sign a power of attorney, what then? Well, guardianship or conservatorship will be needed. And I can tell you, neither of those are a quick or inexpensive solution. They take time, they cost money. There are some possible workarounds. If, for instance, Mrs. Tanaka had put someone else on her bank account as a joint owner or an agent, or had set up auto bill pay for some of her usual utility bills. That might solve some of the problems of managing her finances. Direct deposit into her bank account is another uh, possible solution that could help. The takeaway here is that it is far more economical to retain an attorney to help create a power of attorney than to just do nothing and leave it to your family to file for guardianship later on. So what if there's no advanced healthcare directive? As you know, the advanced healthcare directive is the legal document in which you give another person authority to manage your healthcare decisions if you're unable to do so. Sometimes this is called a medical power of attorney. And the medical agent is the person that helps with that decision making. A good advanced healthcare directive should name both an agent and an alternate agent in case the first person named is not able to do the job. This is also true for the power of attorney. It is very helpful to have a backup person, standby person, in case the first named is not available or able. And it might be needed in either case if the agent that's named, either for finances or medical treatment decisions, is an elderly, frail spouse, which is often the case. Husbands and wives name each other, and it might have been fine 30 years ago, but it might not be fine now if the spouse is frail, perhaps has cognitive impairment themselves. It might not be a good idea. It might be a good idea to have the alternate if you've got, uh, for instance, an adult child with a history of substance abuse. You don't want to put that person as an alternate on a power of attorney, or you might just have a person who is totally unwilling or doesn't have the skills to do the job. If there's no advanced healthcare directive, then family members and other interested persons are going to be required to appoint a surrogate from among them. This is the process that has been set up to help provide hospitals and physicians with decision makers. It is a remedy short of going to court. It can, in some cases, in case of a crisis, delay care if there is no decision maker immediately available. And it is up to the primary physician to ask about who the interested persons are and make it clear that a decision maker has to be selected. However, it's not the physician that chooses the surrogate. Uh, this is something that has to be done by the interested persons. And they should be looking at who has the closest relationship with the person and who is most likely to be currently informed of the patient's wishes. Physicians often look first to the spouse and then to adult children, followed by other family members who may have a close relationship. The surrogate then steps up and will make all healthcare decisions for the person, except for the artificial nutrition and hydration decision, which requires other conditions. And they need to make these decisions based upon what they know of the patient's wishes and what they believe to be in the patient's best interest. In some cases, interested persons may seek guardianship. They may not be able to come to agreement as to the decisions that are made by the surrogate, or they may not have a surrogate who's willing to step forward and take responsibility. Any of those cases may be a reason to seek guardianship. And in fact, in some cases, guardianship may even be advisable even if there's an advanced healthcare directive or a power of attorney, such as when the medical or financial agent fails to act, or again, there is substantial disagreement over the actions taken. So let's look at another case study. George, 82, had a catastrophic stroke. His wife passed when he was 70, and his daughter, his youngest daughter, moved in to care for him a year later because he was beginning to show signs of dementia. The rest of his children, the other four, live on the US mainland. His youngest daughter has been his only caregiver since moving in with him. His dementia has progressed to the point where he doesn't recognize his children or other family members. He can't care for himself anymore. And there was no discussion about these end of life issues because it was considered bachi, bad luck. So it was a subject to be avoided. There was an understanding, however, unwritten, that the youngest daughter would speak for him since she was close to him and she was his lone caregiver. So after thinking about this, the youngest daughter decided to take dad home and get hospice care arranged at home. However, after a few days, the oldest son, the big brother, came home and full rank and things blew up because he felt that dad should go to rehab and recuperate. There was, again, no advanced health care directive. So, who should determine the next steps for George, considering that his wishes were not documented in an advanced health care directive? Who are the interested persons? Well, clearly his daughter, who lives with him, his oldest son, yes. Other children in the family, yes, perhaps. What about the PCP or his geriatrician or his best friend? Uh, who might have heard George express his wishes regarding his end of life care? Who has a close relationship with him? The care team at the hospital has to weigh who seems to have the closest relationship, who would be most likely to know his wishes. And then they have to help the surrogate or the person who will become the surrogate understand that they need a decision maker who has the best chance of knowing George's wishes. And as I said, if there is not agreement, one or more of these interested persons may seek guardianship. So now we get to guardianship. And what is that? So again, to review, there's no advanced health care directive. The law provides for the appointment of a surrogate. If there's no surrogate, then you may need guardianship. And if there's no power of attorney and no trusted family member on joint accounts, there's been no effort to set things up electronically with payments and deposits, then you may also need guardianship. The person that is the agent, that is the guardian, is basically an agent appointed by the court. And this person, this guardian, has to abide by all the restrictions ordered by the court. A person on a power of attorney is not constrained in the same way. However, in both cases, a power of attorney agent, privately appointed, and a guardian both have to make decisions that are in the best interest of the person who gave them that authority. When guardianship is requested by petition, it will only be ordered if there is a very high standard of evidence, because guardianship due to incapacity does involve a loss of personal rights, freedom, and in some cases affects dignity. This very high standard, clear and convincing evidence, is required before guardianship will be ordered. In other words, the incapacity has to be proven, and there has to be a showing that there is no other solution that is less restrictive than guardianship. In some cases, an emergency guardianship may be needed. In these kinds of cases, it can be obtained if the court is convinced that the person or the patient will be substantially harmed before there can be a hearing on the appointment. That harm may be physical, it may be financial, but the person seeking guardianship to protect the patient has to submit an affidavit or give testimony regarding the substantial harm to health, safety, and welfare that they fear. The court can go ahead and appoint an emergency guardian even without notifying the person who will be under the guardianship at the initial stages. They then have, after the emergency guardian is appointed, they then have 48 hours after to notify the person under the guardianship. And a hearing will follow after that to revisit the appropriateness of the appointment. I'm walking into territory that Roland's going to cover, but this is just so you know, there are instances when an emergency guardianship may be required. As I think I said, there has to be imminent risk of harm, and it can be financial harm or it can be physical harm. So the guardianship may be needed to save a life or to prevent financial harm. The emergency guardian's appointment and authority may not exceed 90 days, and they can only exercise the powers that are authorized in the court's order. So the takeaways from all of this are that the legal documents you need to be sure that your loved one has for supported decision-making are the power of attorney document and the advanced health care directive. If there's no advanced health care directive, then a surrogate decision maker is going to have to be appointed. If there's no power of attorney, perhaps adding an agent or a joint owner to a bank account may provide a person with another decision maker with regard to finances. Obviously, this has to be done before loss of capacity. And if there are no such designated agents on bank accounts and so forth, guardianship conservatorship will be required. The bottom line here is if a person appears to have capacity to understand and sign these documents, they should be encouraged to do so. For many in the early stages of dementia who appear to have capacity, it's vital that this be done before the disease causes a further decline in their capacity. Now, let me turn it over to Roland Lee from the Office of Public Guardian, who's going to help you further understand guardianship. And I'm stopping my sharing. Hopefully that means, Roland, you can jump on.
Okay, I will try to see if I can share my PowerPoint here. Here. Is that good? Can everyone see that?
Not yet. Ah, there it is.
Okay. Thank you very much, Laurie, and aloha, everyone. Wanted to just say thank you to Alzheimer's Association, Ivy, Gina, and also the Hawaii Pacific Gerontological Society. Thank you very much for all the good work and partnership here. Much needed information, and let's get started. Give me one moment. I'm timing myself. Okay. So what I want to talk about today is just OPG. We're public guardian, and basically I am the director, and we are here to serve when there are no friends or family to be guardian, but if a guardian is needed. So we will go over our mission statement, types of guardianships, guardianship as a legal status, and the services that we provide, the responsibilities and duties, and then we'll open up for questions. So our office, our mission is to serve as public guardians for incapacitated persons. So you might be asking yourself, what does it mean to be incapacitated? Incapacity is a spectrum. So you may have someone on one end of the spectrum that has zero capacity. Person is comatose, person is incoherent, that's zero capacity. And perhaps on the other end of the spectrum, we are looking at normal capacity, which I would give it a 10. A lot of people that come into OPG fall somewhere right in the middle. And capacity, like Laurie had explained, is a legal status and basically needs to be determined by a doctor. And a doctor should, I would assume, do a full evaluation to evaluate what can a person decide upon and what can a person not decide upon. So as public guardian, we are court-appointed professionals who strive to make informed decisions in the best interest of persons we serve by carrying out all responsibilities with competence and efficiency, respect and compassion, humility and integrity. Now, the word competence sometimes is used interchangeably as capacity, but for our purposes, OPG is, we use the term with competent, meaning that if the person has understanding about something. So person may not understand something about engineering, something very highly different than what they're used to. They don't have the competence of what engineering means, but that doesn't mean they don't have capacity. Capacity means that person doesn't have perhaps part of the brain. So if there was a brain injury, or for that matters, if the person has declined and cannot make a decision because of the cognitive decline or impairment. So as public guardians, we safeguard the rights, dignity, humanity, quality of life of each protected person entrusted to our care. Types of guardianships. There are unlimited guardianships and limited guardianships, but I'm going to reverse that. I would like to talk about limited guardianships first. The court can order limited guardianships, which, like I said, on a spectrum, someone might be able to make some decisions, but not others. They might decide upon where they would want to live, and they can do that, but they might not be able to do and make decisions on more complex tasks, such as writing a check, or for that matter, is keeping an account of money in and money out. For example, there may be bills that the person needs to pay, but they're unable to pay the bills and then just to make sure that there's enough in the account. So they may need help with that. And basically, the limits of the guardianship is limit on the power of the guardian. So basically, the guardianship is specific to helping the person with certain tasks, such as healthcare decision-making and maybe finances. Unlimited guardianships, on the other hand, gives the guardian full power to make decisions for an individual. And that includes, but not limited to, healthcare decisions, placement decisions, financial. There's also decisions of medical and education, to marriage, if the person is younger, and also even end of life decision and hospice care. So our office at times, one time or another, needs to make all of those decisions. So unlimited guardianships, although unlimited in decision-making power, doesn't grant the guardian power to forcibly make someone do something. So the guardian can make decisions on, let's just say, medications and treatment. But if the individual decides that they don't want the treatment or they don't want to take the medications, we cannot forcibly make someone take medications or forcibly place someone somewheres where they don't want to live. We can consent to that, but and although that might be in the best interest of the person, because of the care they need, if they decide that they want to live in the same home that they've been living in for 50 years, there's no way to forcibly take the person out and then put them someplace else. It's important to know that because there are limits on the guardianship, although it is called unlimited guardianship when full decision-making power has been granted to the guardian. And that goes with public guardians as well as private guardianships. Laurie already talked about emergency guardianships. Usually, from our standpoint, we see emergency guardianships and we get called for emergency guardianships when there is a medical emergency. We're not talking about psychiatric emergency. So for example, if someone is in a car accident and ends up in the hospital, has no friends or family available that the doctor knows, but needs emergency treatment of some sort, then they may call the court, and the court would then appoint a guardian to make the treatment decisions because it's a life or death situation. And the court would determine whether that is a true emergency or not. Many a times people are hopeful that the court will grant an emergency guardianship for psychiatric issues, but there are laws and resources for that, and it's different. Like Laurie said, it's 90 days, a limit on that. And then usually the court will continue or have another hearing for a more permanent guardianship thereafter the 90 days. There are also substitute guardianships, which means that there's a guardianship in place already, but the guardian might be out of town for 6 months and there's no one to decide and to make decisions for this person or to oversee their care. Then the court might appoint a guardian to be the substitute so that the substitute guardian can make decisions for that limited time. Now there's interchangeable terms. One is called guardian of the person, and the other one is guardian of the property. Usually guardian of the property would be also known as the conservator. In these circumstances, the guardian of the property manages and oversees property finances, monies, accounts, income, anything to do with money for the individual. And for OPG, we are limited to being the guardian of the person with limits on managing finances. If the person has like limited amounts of money or income coming in to pay for services such as caregiver services, or maybe just very simple educational services. But when a person owns property, boat, businesses, or maybe apartment, then that's way beyond what the public guardian can do as far as liquidating some of that if the person needs the money to pay for their care, or for that matters, if there needs to be management of the properties. Then a conservator has the power, or is given the legal rights to make those decisions on behalf of the person. Situations come about when there are more than one guardian. It's like a guardian and a co-guardian, or maybe a conservator and a guardian of the person. There needs to be a meeting of minds, meaning that, let's just say that the person needs to be in a care home, but the placement of the person in the care home depends on how much money the person has in the management of the money. So if there's a conservator and there's a guardian of the person, there needs to be a meeting of minds and an agreement. If there's not a meeting of minds, then of course that cannot be done until there's an agreement that the conservator will pay for the caregiving of the person. But there's also one more meeting of minds, which is the person themselves. So there's three people that need to be in the picture here. Person also has a will of their own. So the guardian can decide, let's just say it's in the best interest for the person to be placed in a care home. And then the conservator will say, yes, we'll pay for it. But if the person's will is, I don't want to live there, then there's no forcible way of getting the person to that home, even though that is the most probably appropriate care that the person should be receiving. So there has to be a meeting of minds of all three parties. Now, if you think about yourself and in your own lives, you may have decided upon where you live based on how much money you have, and then you went and lived there. So those three parts all came together under one person. But when it's split, then there's got to be some cohesiveness to the decision making, which sometimes gets to be challenging, but not impossible, because I think more often than not, there are agreements. Now, Laurie talked about POAs and advanced healthcare directives. These are really good alternatives to guardianships. Guardianships in general are very, very highly restrictive, especially unlimited guardianships. And unlimited guardianships in one court hearing, once the judge professes the word unlimited guardianship for so and so and so, the person automatically loses their rights to make decisions on all life decisions. Like I said, for healthcare, placement, education if they're younger, even end of life decisions. So that's why I would really point to what Laurie's presentation about getting power of attorneys as alternatives, medical surrogates if there is a medical emergency or medical situation, advanced healthcare directives, if at all possible, to be set up before needing a guardian. Guardianships are legal statuses. Some people, or I think in generally speaking, people might think that guardians are case managers. We've often been called case managers or caretakers, but that's not always the case. I've skipped to the second point here. Basically, we are not caretakers, at least as public guardians, but we might fulfill that role. We might bring groceries to someone because they're unable to do so for themselves. Or we might fulfill the role of case manager, meaning that we'll set up services for the person, but it doesn't mean that we are a case management service. We are decision makers that give consent on what's in the best interest of the person. So I'm sure a lot of you out there might be caregivers yourselves. And so you may be wondering, should I be getting a guardianship for my loved ones? And what is the process? So the process is that there has to be a petitioner. That means a person bringing the case to court for the court to decide whether a person is actually incapacitated or not. And how does the court decide that? Court has to get documents from usually a doctor who's evaluated, what we call a respondent or the person, and whether or not that evaluation says on their what can the person decide upon? What can the person not decide upon? And that's usually a good indicator whether the person is incapacitated or not. And if so, then the court would bestow that power or appoint the guardian for the person. And at that point, the person has a decision maker. OPG and guardians in general are decision makers, and we are, for lack of a better term, I guess maybe the external brain for the person, because the person doesn't have the wherewithal to make decisions for themselves. The conflict that caretakers sometimes need to resolve is whether or not being the caretaker and also having all this power of decision making, and also perhaps the person's finances, whether they all kind of, what is there a conflict or not? So for example, I've seen individuals who have, an individual anyways, that who has paid themselves $300 an hour to feed their friend because they have the money. So they're the caretaker on the one hand, and then they're also, on the other hand, they have the decision-making power and also the money. So the question is whether or not that is the going rate for, just feeding someone, and as a caretaker. And although I understand, and we do understand that as caretakers, there's caregiver burnout, and sometimes caregivers, generally speaking, might give information, I'm sorry, caregivers might even give up their jobs in order to caregive for a loved one. The question is sometimes how much or should a caregiver be paid with the accounts and the monies that a person already has and through their accounts. So these are some conflicts that come up. As guardians, we have priorities. Usually first priority is taking care of a person's medical needs and psychiatric needs. Then, of course, basic needs as well. And they all kind of come together. Guardianship in general is like a hub on a wheel. And I'm not going to go through all of these in the interest of time, but what we try to do is activate this wheel by activating these services and also gaining intimate knowledge of an individual. But as a private guardian, I'm sure that people who petition to become guardian for a loved one, they will already have intimate knowledge about what a person likes or does not like, their cultural background, and any kind of background, educational background, what would they like to do to socialize, and just all of these things to bring about a good quality of life for the person. And OPG, we have 700 people under our guardianship. And so we have a lot of people that we need to make sure that we have intimate knowledge about, and that we understand not only what their needs are, but also what they like and what they dislike. So with that, I'm going to end because I think there's in the interest of time, there's 15 minutes more for questions. Thank you very much.